Good morning. This is your Kelso Report for Wednesday, February 1st. I'm your host, Clark Kelso. The legislature has adopted the goal of trying to secure an adoptive home for a dependent child that is free from the influences of criminal activity and substance abuse, and providing maximum safety and security for the child. That is why Welfare and Institutions Code section 16514C generally prohibits the placement of a dependent child with a section 602 ward in the same household. In TW versus San Diego County Health and Human Services Agency, a mistake was made in the initial placement, and a dependent child was placed in a home where there already was a section 602 ward with prior gang history. The appellate court held that the juvenile court abused its discretion when it denied the agency's petition to remove the dependent from the home of his prospective adoptive parent. And the appellate court sent the case back down to the juvenile court to grant the agency's request for removal. Next, we have a case dealing with the recovery of costs in the context of civil procedure. Recovery of expert witness fees that are incurred by the prevailing defendant was the issue before the 4th District in Shaban versus Wet Seal. The plaintiff here had sued for wrongful termination. The defendants prevailed after a jury trial, and then Wet Seal submitted a memorandum of costs claiming about $29,000. The plaintiff filed a motion to tax costs, but the trial court denied that motion, and the plaintiff appealed. Now, the only novel legal question in the case worthy of publication was whether the defendant could recover the amount it had paid to the plaintiff's expert witness to take his deposition on a particular day. They had some scheduling problems, as well as extra charges the defense incurred in expediting the deposition transcript. And that was necessary because the expert was unavailable for an earlier deposition date. The defendant had made an offer to compromise under Section 998, which the plaintiff turned down. So the case was governed by Section 998's costs provisions. The applicable subdivision, Subdivision C1 of Section 998, provides that, quote, the court, in its discretion, may require the plaintiff to pay a reasonable sum to cover the costs of the services of expert witnesses, actually incurred and reasonably necessary in either or both preparation for trial or during trial of the case for the defendant, close quote. The court held that this section permitted recovery of the costs, even though the expert was the plaintiff's expert instead of the defendant's expert, since nothing in the language of Subdivision C1 clearly limited recovery to only the defendant's expert witnesses. Note the language of the rule said services of expert witnesses. It didn't say services of the defendant's expert witnesses. Our next case involves administrative law and driving under the influence. Various state statutes and regulations provide the procedures for determining the accuracy of instruments used in breath alcohol testing. One of those regulations requires, quote, periodic analysis of a reference sample of known alcohol concentration, close quote, where periodic means either a period of time not exceeding 10 days or following the testing of every 150 subjects, whichever comes sooner. In Lane versus Valverde, the driver was tested about 5 hours after the breathalyzer had been checked against the reference sample, and he scored a .20 blood alcohol level. Now, that particular breathalyzer was not checked again until 11 days later. And so the defendant claimed that this subsequent failure to conduct an appropriate periodic analysis invalidated the results of his test. Well, the court rejected this argument and properly interpreted the regulation as meaning that the breathalyzer's results are considered presumptively valid for up to 10 days or 150 subjects, whichever comes sooner, after being checked against the reference sample. But I'll have to give counsel an A for effort on this one, to have even thought of trying to make that argument. Finally today, an area of government law involving the Peace Officers' Bill of Rights. Now, you can't say that peace officers don't get notice when they are about to be disciplined. In fact, according to the law, they get 2 notices. First, they get an informal Sullier notice, named after the case of Sullier versus State Personnel Board, and then they get a formal notice, quote, in writing of the public agency's final decision to impose discipline within 30 days of its decision, close quote. In Nevis versus CDCR, the department sent the plaintiff the informal notice on December 30th, 2009, and then sent the formal notice of adverse action, dated January 27, 2010, which was received by the public safety officer on February 1 or 2, 2010. Well, the officer claimed the discipline was ineffective because it came more than 30 days after the December 30 notice. But the appellate court saved the day by construing the statute as involving that 2-step notice process. The December 30 notice was not the final decision. It was only a preliminary Sullier notice. The final decision was actually made on January 27, and that notice certainly was received within 30 days. Well, that's it for today's Kelso Report. Have a great day in the law.